right. Good morning, chat. My name is Kono. I am a seventh year class action attorney working in California. And fun fact, I've actually been certified class counsel in data privacy class action cases. And today I'm talking about Twitch has been sued by its own creators in a class action lawsuit over its generative AI policies. So what's on the docket for today? So today we're going to be discussing first how Twitch opted in all of its creators' data for Gen AI by default, the specific allegations in this new case that was just filed on the 20th, and then what Twitch's likely response is going to be because, it just got filed. I don't even believe it has been served yet. So we don't know at this moment what Twitch is going to be doing. So on August 12th, 2026, Twitch confirmed that it now uses creators' content for AI training through a post that it made on Twitter. We've added a setting that lets you opt out of having your channel content used to train generative AI content models across Amazon. This post linked to a post in Twitch's health FAQ, which purported to explain what this meant. So here you can see it. When we click on that link, we can see what Twitch has helpfully provided for us. Essentially, Amazon is using Twitch as a method of obtaining new raw data for its own Gen AI models. What are generative AI content models, and what does it mean for content to be used to train them? Generative AI content models are AI tools that can help create or synthesize content outputs like text or images. When given instructions or prompts, they're also trained on content. When you allow training, that means that your content may be used for future Gen AI model improvements. An example of what happens when you allow your content to be used for training a Gen AI content model is that your audio might help refine models to create speech to text, which would help improve captions at Twitch, but would also help improve captions across Amazon. Also, they might be using your speech, your language, the fact that Twitch streams are much more casual than other data sets that you might find to be able to create AI that has a more natural sounding voice. They might literally be stealing your voice as a Twitch content creator. On that same day that this was added to the FAQ, Twitch also changed its privacy policy to also inform users that they are now, by default, using their information to train AI. How Twitch uses personal information. Twitch uses such information to operate, maintain, enhance, blah, 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 and to test and improve technology, including machine learning and artificial intelligence, to support and enhance the customer experience across our products and services. This includes using data to develop our generative AI models and services. And then the R there stands for Amazon, because it's not just Twitch that is benefiting off this. It is their parent company, Amazon. Amazon's basically using Twitch, which has never turned a profit in a decade, as a mechanism to train their AIs. Basically deciding if we weren't able to make any money off of this after so many years, we might as well get value out of it somehow. So it's been reported, however, that in 2024, Mike Minton, then Twitch's chief monetization officer, acknowledged that Twitch content was already being used for AI development and a prototyping, not in any kind of production scale capacity, according to 404 Media and Tech Times, as reported by Courthouse News Services. Mike Minton later added that any AI training was being done, and this was back in 2024, within the bounds of user trust, within the bounds of privacy regulations. However, in an August 12th stream following the company's post about the opt-out setting, which we'll be talking about here in a moment, Minton, now Twitch's chief product officer, defended the setting being opt-out instead of opt-in, saying if it was opt-in, nobody would opt-in. That's honestly the answer. So on August 12th, when all of this went out, it was turned on by default. You can see it right here, the training for AI, for generative AI, which is in your security settings. So everyone already had their generative AI turned on by default. Twitch had massive backlash at this, both on Twitter, and then put out a video explaining, Mike Minton explaining why they made this decision.
Now, why is it not opt-in? That's what everybody is here spamming in chat. I get it. Let me opt in versus making me opt out. Well, there's an honest answer, and I think most of you probably can appreciate this. Like, if it was opt in, nobody would opt in. That's honestly the answer. So by it's going to be on by default, and as I said, almost every content service in the world is on by default.
So there, Mike basically gives the game away and says that it was a decision by the business, a knowing decision to force everyone to be opted into AI by default because they knew otherwise there would be no way that folks would willingly, for free, give their information, give their likeness, give their voices to Twitch, to Amazon for nothing, essentially. After this came out recently, so that came out on August 12th. On August 20th, we had a class action lawsuit filed entitled Warren Pandacea versus Twitch Interactive Inc., again, the streaming company, and Amazon.com Inc., who is getting the benefit of the streaming company's information to train their AI models. This was filed in the Northern District Court of California with 4 causes of action. What we're going to be doing is looking at the allegations in the case, and then we're going to be going through each of these causes of action so you can understand what they mean. Breach of implied contract, unjust enrichment, breach of express contract, and violation of California's unfair competition laws, sometimes just called the unfair business laws. So let's take a look at the allegations in the lawsuit first. So this is about the plaintiff Pandacea. Plaintiff Pandacea is a citizen of the state of Connecticut. At all times relevant to this action, plaintiff resided in Fairfield County, Connecticut. Plaintiff has been a frequent and regular Twitch content creator for close to 10 years, with over 900 followers on his channel. In the course of creating content on Twitch, plaintiff has streamed over 1,000 hours of content. Plaintiff has invested substantial time and money into bringing awareness around his content, including tens of thousands of dollars, which is insane to me, in equipment, props, and subscriptions used in connection with his streams. For instance, Plaintiff has streamed footage of his building Lego sets and playing video games. Without guarantee of success, Plaintiff has incurred substantial time and monetary expense for the sole purpose of bettering his viewers' experience. So basically, Plaintiff Pandacea is someone who has spent 1,000 hours of time doing content creation. He claims to have spent thousands or tens of thousands of dollars as part of that time. It's up to you to decide if that's reasonable or not. As you may or may not know, my Vtuber model has cost me a total of $101. And so he is what's called the proposed representative plaintiff. When you file a class action, you don't have to automatically have hundreds or dozens or thousands of people all set up and ready to sue them. Instead, what you do is you find someone who's representative of the group as a whole, and that person sues on the behalf. It's called a putative class action. Putative meaning that it hasn't been certified by the court as a class action that actually draws in everyone else yet. So something you might be wondering is, why was this lawsuit filed in California at this moment if this guy's from Connecticut? He's doing his Twitch streaming from Connecticut. That's what's happening. So plaintiff Warren Pandacea is a citizen of the state of Connecticut. However, defendant Twitch is a citizen of the state of California, while Amazon is a defendant who is a Delaware corporation with its main place of business in Seattle. So that means that you could sue as a plaintiff in any one of these places, because each of these places would theoretically have enough of a connection to the lawsuit. You could sue Twitch and Amazon from where you live in Connecticut. You could sue them where they work in either Seattle or in San Francisco, or even potentially in Delaware. Because a corporation is a citizen of both the states where it is incorporated in, like Delaware. So you could expect to be sued in Delaware, but also where you have your main headquarters, like Seattle or San Francisco. The Northern District Court of California is also widely considered to be a pretty plaintiff-friendly federal court to be in, all things considered. It's where if I am removed, which means drawn from state court to federal court in California, where I do 99% of my work, if I'm in the Northern District Court of California, it's all right. It's fine. I'm not mad. Now, if I'm in the Eastern District Court of California, different story. And that just is all based upon the judges who are there, the kind of law that's generated over time by what's called precedent from the decisions that come there. So the lawsuit goes in about the allegations regarding the length of time and the effectiveness of the opt-out. So earlier we were talking about how Twitch may have already been using AI since 2024. So at the time everyone was defaulted in, Did they already have all their passive VODs stolen, all their clips, all their highlights? We just don't know, which is why we have what's called upon information good faith belief. This just means you think something's true in a lawsuit. You're alleging it's true. You might not have all the information to prove that it's true, but you believe there's a reasonable likelihood it'll come out in this lawsuit. So here they allege the defendants have been mining creators' content on Twitch to train AI without content creators' knowledge or consent since as far back as 2024, which was prior to updating those Twitch settings we were just looking at, like the privacy policy, to allow creators to opt out of the collection. When users question if their content is already being used to train AI without their knowledge, Minton, the guy who said, we had to make it opt out because no one would willingly opt in, said, I don't actually know the answer to that question because I don't know what Amazon has done in terms of model training and what they've used and not used. So it is, standing here today, completely possible that every single VOD that I've ever put out, that every highlight I have, every clip that I've made has been given to Amazon's AI generative machine. That every Twitch creator, even those who have opted out between 2024 and 2026, or just in that split second before they could opt out, have had some amount of their data taken and fed to the giant Amazon meat grinder. So they also make different allegations regarding how the rollout happened. So defendants know that the Twitch community of streamers is largely opposed to the use of generative AI because we're people, because I'm a person behind this. And I don't believe me, for example, that AI should be used in content creation. I think it's wrong. I think it is cutting corners. And I think it genuinely is making our kids dumber. Since the most prevalent generative AI products are trained on books, images, videos, and other materials scraped from the internet without consent. Everyone by now has seen those videos of like books having their spines ripped apart and then speed ran through by machines to understand all that nice juicy information inside. It's gross. It's disgusting. Even Twitch's approach to breaking this news shows that defendants are bracing for backlash. That tweet we just saw earlier. Instead of telling the community that Amazon's training on Twitch's user content, Twitch framed the announcement as adding a setting that lets you opt out of having your channel content used to train generative AI content models across Amazon. They basically said, hey, we're not here to take all your information and give it to Daddy Bezos. Instead, we're giving you the option for us to not do that. Maybe what they mean is stop doing that. And we just genuinely do not know right now, which is terrifying. So the allegations of the lawsuit go further into what are called, unlawful actions. Twitch stream recordings are incredibly valuable for defendants, offering thousands of hours of audio and video content to help train AI models. Genuinely, with the millions of content creators, it is billions of audio and video content hours that can be fed to AI models. It is that amount of information is insane, and the cost to acquire that much natural speaking content is just not out there. Rather than seek permission or pay a fair price for the audio-visual content streamed on Twitch, defendants harvested content creators' streams at scale with content or compensation. This is going back to those allegations that they were already doing this back in 24. And right now, they're still doing it, in 26 for those folks who maybe haven't logged on to Twitch and or gotten the news that they have to opt out. Maybe their highlights, maybe their VODs, maybe their clips are being fed to the giant meat grinder. Content creators such as plaintiff and class members will never be able to claw back the intellectual property unlawfully copied and used by defendants to train their Amazon's generative AI. Once AI ingests content, that content is stored as neural network. It's not capable of deletion or retraction. You can't get that back once it's already gone. So back to the actual plaintiff's allegations regarding his own Twitch channel and his own data being taken by AI. The lawsuit explains that the plaintiff had no reason to believe that defendants would be using his content to train their generative AI products, and that the plaintiff morally is opposed to such use of his original content. In fact, once this plaintiff found out about the opt-out option rolled out by Twitch earlier last week, he's changed his Twitch account settings to stop defendants from using his content to train AI. I have as well. Plaintiff maintained his Twitch account and created and streamed his content subject to Twitch's terms of service and privacy notice. That same privacy notice that they changed the day that they did this had defendants disclosed that content and communications on the platform would be captured and used to train Amazon's generative AI products. Plaintiff would have opted out immediately. as he in fact did as soon as he learned of the setting. It would not have made his content and communications available on the same terms. He wouldn't have just freely given his content to Twitch. What's actually at stake here? So this is a class action, as I was discussing earlier. So that means that this plaintiff is bringing this action pursuant to what's called FRCP Rule 23, which we'll take a look at in just a moment, and it's on behalf of the following nationwide class: all content creators who use the Twitch platform at twitch.tv and whose content was used to train Amazon's AI products. Now, there's something a little bit weird about these class allegations. Usually when you deal with class allegations, you have what's called a relevant time period, how far back the lawsuit can go. However, as we know, based on the allegations in the complaint, as we know, based on Twitch not knowing, apparently, if their content has already been going to Amazon, we don't know if this merely is going back to August 12th, 2026, or all the way back to 2024, when Twitch started first experimenting with general AI. So what is FRCP Rule 23? And this is just a little fun aside. So what's a class action? So a class action is when you have one or more members of a class may sue or be sued as a representative parties on behalf of all members if they go through what's called class certification. And at class certification, the judge doesn't make any substantial decisions. He doesn't decide, are you right in the case or not? All he decides is, one, if the class is so numerous that joinder of all members is impractical. And we have, at least in the United States, hundreds of thousands, millions, maybe, of different content creators using Twitch. So there is, more than enough folks for it to be so numerous that joinder is impossible. Usually that caps out around 40 to 80, depending on the case law that you're looking at. That makes having a bunch of mini trials just so substantially difficult. Number two is if there are questions of law or fact common to the class. So the answer to that is probably yes. All of these folks are using the exact same privacy policy. They're abiding by the same Twitch creator agreement, and either their information is being stolen and fed to the AI or it's not. So there's questions of law, questions of fact that are perfectly common to all of these folks. Number three, the claims or defenses of the representative party. That means the plaintiff here are typical of the claims or defenses of the class. Here's where I have a slight issue. There is case law that says that damages isn't necessarily something that matters at class certification. The idea that someone who has only 900 followers has spent tens of thousands of dollars on equipment, there is a discussion if that is reasonable or not. However, the actual damages from the case, the damages of having potentially his likeness stolen, that is typical of all the other folks who have been around on Twitch for the last few years, since 2024, like yours truly. And finally, that the representative parties will fairly and adequately protect the interests of the class. What that means is that the plaintiff here isn't a liar and that they have good attorneys. I've looked at the attorneys. I'm not going to dox them, but I'm incredibly impressed by the plaintiff's counsel that this guy has. Incredibly impressed. So let's look at the actual causes of action here. So we have 4 of them, and the first one is for breach of implied contract. Essentially what breach of implied contract means here is that, there is an understanding that Twitch will pay you for what you give to them. When you give them your likeness, there is a royalty agreement that if they use your likeness, that they have to pay you royalties. There is an idea that bits or subs or cheers, are going to be cut at different percentiles based on, if you're a partner plus level 2, all of that, with the remainder going to Twitch. So, you get a share of the revenue that you're making. By utilizing the Twitch platform, creating accounts, streaming original audiovisual works, and participating in Twitch's revenue sharing program, plaintiff and class members each respectively entered into an implied and fact contract with Twitch, the terms which are implied from the party's conduct. Again, if I give you something, you give me something back. So they're alleging that the breach of this implied contract was that they were exploiting their creators without any kind of payment by feeding them to the Amazon generative AI. Plaintiff and class members would not have submitted their original work product to Twitch had they known the defendant had no intention of keeping this implied contract. We wouldn't, have been streamed on Twitch potentially if we knew we were going to get screwed and I was going to become part of the next Alexa. Defendant breached this implied contract with plaintiff and the class members and the implied covenant of good faith and fair dealing by capturing their original work product and using it to train Amazon's AI products without authorization, by exploiting creators' content outside the scope and purpose of their relationship and without any share of the resulting value. In bad faith, enrolling every creator by default, knowing that if they didn't take this value by default, that no one would willingly give it to them. I think this is an excellent cause of action. Usually when you're dealing with a lawsuit, the stronger causes of action are going to be, your first one, your second one. I think this makes a lot of sense. I think that a jury would find that if two parties have been in a relationship where one of them is giving the other one their work for payment, that if the other one starts secretly stealing their likeness, stealing their work for additional means while giving them additional payment, then that is going to be, breaching their implied contract. It's a breach of the idea of good faith and fair dealing within that contract. So the second cause of action is for what's called unjust enrichment. Essentially, the second cause of action demonstrates that Twitch and Amazon have unjustly enriched themselves on intellectual property owned by their creators, which is me, a Twitch streamer, and in doing so have done it in order to get a leg up on their competitors. Google, for example, is reported to have negotiated a $60 million per year fee to Reddit for its right to train its AI model on Reddit users' posts. And Reddit has reported more than $200 million in AI data licensing revenue, including a comparable arrangement with OpenAI. By taking plaintiff and class members, again, that's Twitch content creators, audiovisual works, and communications without any license or negotiation, defendants obtained for free what participants in the AI market pay tens of millions, hundreds of millions of dollars per year or more to acquire, and have avoided this acquisition cost that their competitors bear. They've essentially cheated by screwing over their Twitch content creators, the same Twitch content creators that they know would not have willingly given them this audiovisual information for free. The third cause of action is for breach of express contract. I think this is likely going to be the weakest of the four different causes of action. So this is essentially arguing that Twitch has breached the language of its own privacy policy by mandating AI by default and using the data as it taken for its users for general AI. This action focuses on what's called a Section 8 license, whose stated purpose was the exercise of rights in connection with monetizing the Twitch service. Basically that we are receiving from you a license to broadcast your audiovisual work on our website to creators. I'm not giving you a license to use my data for your Amazon AI model. And again, we don't know if they were doing this back in 2024. This idea is that if they have been doing that since 2024, they have been breaching their own contract, their own privacy policy, which we took a look at earlier in this video, for years. The privacy notices covenant that Twitch will not materially change our policy and practices to make them less protective of personal information collected in the past under a prior version of the privacy notice without the consent of affected individuals. So part B here is this idea that the privacy policy, the old one, stated that it wouldn't, give you fewer rights without giving you an opportunity to change that. And they've violated that by making this, opt out only, because it's likely at some point that during that intervening time, at least in 2024, 2025, 2026, that your material got sent over, or just the fact that they've changed the privacy policy to make it less protective by making this opt-in by default. Second, defendants breach privacy notice's non-retroactivity covenant, which we were just talking about, by applying a materially less practice, generative AI training, to content, communications, and information collected in the past under prior versions of the privacy notice without the consent of affected individuals. And that in doing so, they breach the privacy notice's advance notice promise by providing no notice and no opportunity to decline before our communications and informations were sent to the program, were sent to Amazon's AI. I think this is a little bit weaker because we don't know for a fact. You have to be able to prove at least two different things here. First, you have to be able to prove that the opt-out strategy is actually less protective than opt-in. As we were watching earlier, at least Twitch's policy seems to be that that is the industry default. So there could be a question of law, a question of fact, as to whether or not that the default was enough. Secondly, there's going to be the issue of whether or not they were actually stealing your material in 2024, 2025, 2026 before the privacy policy change, which let them do that. So you have to be able to prove that. We still haven't been able to prove it. It's still kind of murky. So the last cause of action is what's called a catch-all. It's for unfair business practices. It's essentially the same as unjust enrichment, but it permits what's called injunctive relief because it's an ongoing issue. So basically, by suing for unfair business practices with a current individual who is currently being affected by this, the plaintiff potentially can seek an injunction against Twitch to force them to stop their their opt-out only procedure, and instead either require everyone to opt in affirmatively or stop feeding the information to Amazon in the first place. So it's a catch-all cause of action. It's very similar to unjust enrichment, but it permits them to do that. So those are all the different causes of action. Those are the different allegations in the lawsuit. So, what's going to happen next? In most of these contracts where you sign something off online, you're going to have a agreement. And here, it's the same agreement that I have, the same agreement that I believe all Twitch content creators have, or most of them do. The monetized streamer agreement, which you have to sign off on in order to be able to stream on Twitch, includes what's called an arbitration agreement. So the Black Laws Dictionary defines arbitration as a method of dispute resolution involving one or more neutral third parties who are usually agreed to by the disputing parties and whose decision is binding. So arbitration is basically where, instead of being able to go through court as a class action, what Twitch has the option of doing is filing what's called a motion to compel arbitration, to force the plaintiff here to make good on their arbitration agreement. And as you can see here, and the arbitration section that I've copied from the monetized streamer agreement, it covers any dispute, claim, or controversy arising out of or relating to the agreement, which means, your time at Twitch. And it reminds you, there is no judge, there is no jury in arbitration. What is the plaintiff likely to argue here, if they are being dealt with one of these arbitration motions? So generally, one of the best ways to fight an arbitration motion is to argue that the arbitration agreement itself is what's called unconscionable. What unconscionability essentially means is that an arbitration agreement is so bad that it boggles the mind that it could be enforced by a judge. And there are two different kinds of unconscionability. The first is procedural unconscionability, and the second is what's called substantive unconscionability. We're going to first look at procedural unconscionability. So I'm using California law here because these are California claims. It's in a California court. So procedural unconscionability turns on what's called adhesiveness, a set of circumstances in which the weaker or the adhering party is presented a contract drafted by the stronger party on a take it or leave it basis. So we have to ask ourselves, was there anything, procedurally unconscionable here? Well, yeah, we have an adhesive contract. What that means is that Twitch gives it to you, and you're not in the room negotiating it with you. You have to either sign off on it, or you cannot be a Twitch streamer. So one of these adhesive contracts is standardized, generally on a pre-printed form, and offered by the party with superior bargaining power, here Twitch, on a take it or leave it basis. Here, the monetized streamer agreement was a contract of adhesion for all streamers, as you cannot negotiate it, bargain it, you have to accept it, or you go to kick. So California law has found that if there is one of these so-called adhesive agreements, that it provides what's called a modest amount of procedural unconscionability. It's not, automatically going to win you the day, but it gives you an opportunity to argue that the actual language of the arbitration agreement is substantively unconscionable. I stayed up an ungodly amount of time last night looking at the arbitration agreement, and I thought it was pretty damn good until I noticed a reference to a section. So substantive unconscionability focuses on the actual terms of the agreement and evaluates whether they create an overly harsh or one-sided result. For example, if one party has to arbitrate all their claims, or the claims they're likely to bring, but the other party does not, that would be an overly harsh or one-sided result. So does the arbitration agreement here have any language like that? Is it so-called, just has so much substantive unconscionability in it that it shouldn't be enforced? And I think that there's a decent chance here. So when you look at the arbitration agreement, it states, in a very dense paragraph, I'll mind you, that the arbitrator may not award any damages excluded pursuant to Section 11 which is the limitation of liability in the agreement. So this part of the arbitration agreement is incorporating what's called a damage limitation. So let's read that damage limitation. Further, our aggregate liability to you, that's the Twitch content creator, under any theory of liability in connection with this agreement in the program will not exceed the revenue paid or payable to you under this agreement in the 12 months immediately preceding the date on which the event giving rise to the most recent claim of liability occurred. So Twitch, in their partner and affiliate agreement, basically says that you, the creator, cannot recover all your damages. You can only make as much damages in a lawsuit as we've paid out to you over the last 12 months. And they incorporate this damage limitation into the arbitration agreement, saying that the arbitrator can only give you that much in damages. So this limitation of liability is baked into the arbitration agreement by being incorporated into it. As a result, there's a chance that this is so unlawful as to permeate the rest of the arbitration agreement with unconscionability. Generally, when you decide an arbitration agreement is unconscionable, you have to find multiple provisions. I have not been able to find multiple provisions in a non-employment context, because when you're not working for Twitch, you're working with Twitch. You're considered an independent contractor, so the law generally considers you to be an independent business. But I think this is patently on its face one-sided. I think this is substantively unconscionable. And I think there's a good risk that they might be able to show that this arbitration agreement is unconscionable. So where does that leave us? What's the most likely result here? So again, none of this has happened yet, but I'm predicting that Twitch will likely bring a motion to compel arbitration and may lose on that. I honestly think it's 80-20 in Twitch's favor, but there is a decent chance that the plaintiffs might be able to beat this motion to compel arbitration. But even if Twitch wins, they might still be screwed if plaintiff Pandasia's lawyers do what's called a mass arbitration campaign. This is essentially where you sign up tons of Twitch content creators to overwhelm Twitch with arbitration costs. Twitch, in their arbitration agreement, agrees to use what's called JAMS. JAMS is a third-party provider for arbitration. They usually have retired judges who make decisions for them. A arbitration through JAMS can easily have costs of tens of thousands of dollars per individual, which means that if Twitch wins on their motion to compel arbitration, it might bite them in the butt. Steam had this happen recently, where they got rid of their arbitration agreement because a lawyer basically got tons of Steam users together, launched a ton of consumer arbitration demands, and overwhelmed Valve with costs on this. Hundreds of thousands, millions, tens of millions of dollars of costs. So this current lawsuit is getting a ton of audience right now. And there are, millions, potentially, at least 1 million Twitch content creators in the United States, where you can be a class member for this, who could join this, as part of a mass arbitration campaign. Let's say you get 100, 1,000, 5,000 Twitch content creators to bring arbitration demands. You might have Twitch, you might have Amazon on the hook for 10, 20, 50 million dollars in just costs, not even if they win. So I see this going in one of two ways. Either, Twitch loses his motion to compel arbitration. I think it's 5-1 that happens. More likely, Plaintiff Pandasia and his attorneys may start a mass arbitration campaign, which will force Twitch to the bargaining table. And again, I think they have the ability to do that because I've been incredibly impressed by the attorneys that they have been able to do. So that's everything that I think is happening here. Happy to take questions now that we've gone through all of that material. Thanks everybody. Let's just give yourself clappies for getting through all that. Give yourself clappies. Fucking love all of you.